qualified immunity in its elaboration, which is about 30 years old, arises in a social and historical and political context. It has to do with perceptions of the role of police. It has to do with perceptions of the role of being pro-police or anti-police. And qualified immunity serves if you will, the agenda of judges who are concerned to protect the ability of police to act with minimal regard for the consequences of their victims. Chris is very fortunate to have had the panel he did, and God bless Judge Gregory as well as Judge Floyd. Now, Chris, being the tiger that he is, would probably have won in front of Niemeyer and Wilkinson. But the fact of the matter is that judges have political attitudes and political preferences, and qualified immunity has developed through the Rehnquist court, now again through the Roberts court, and without any regard as to the consequences. Let me give you a notion about this. On May 15th of this year, in the middle of the social chaos arising out of the George Floyd death and the riots, when the Supreme Court had a dozen qualified immunity police appeals pending, and when not only the New York Times, which is of course a Marxist paper, or the Washington Post, which is kind of liberal, but George Will in his column saying, this isn't any good, you've got to take this away. Plus two judges, our Judge Floyd and Judge Lynn Edelman, a judge in Michigan, writing public letters, publications in the press. Judge Floyd had an op-ed in the Washington Post calling for qualified immunity to be done away with. The court denied every single appeal. And let me give you just a thumbnail sketch of what some of them were. Baxter versus Bracey, qualified immunity to officers who deployed a police dog against a suspect who had surrendered and was sitting on the ground with his hands up. Corbett versus Vickers, qualified immunity to a deputy who shot a 10-year-old child lying on the ground while repeatedly attempting to shoot a pet dog that posed no threat. West versus City of Caldwell, qualified immunity to officers who bombarded an innocent woman's home with tear gas grenades after she gave them permission to enter to look for a suspect. Cooper versus Flake, qualified immunity to officers who killed an unarmed man in his parents' home by tasing him 9 times while he was having an acute mental health crisis. Jessup versus City of Fresno, qualified immunity to police officers who, get this, stole $225,000 in cash and rare coins in the course of executing a search warrant. That's because no court had ever said that that violated federal law. It's true, look it up. Kelsey versus Ernst, qualified immunity to an officer who grabbed a small woman in a bear hug and slammed her to the ground, knocking her unconscious and because she walked away from him after he told her to get out of here. That's what our Supreme Court decided about 8 weeks ago. They have, it has to be said, an agenda. And it's our role to change it. I have just filed a cert petition in which I have raised these issues, but I have not made the legal arguments that have been made by so many lawyers in excellent presentations. And I should say, by the way, that the Cato Institute, it's a libertarian think tank, they have embarked on a qualified immunity initiative and provided absolutely superb amicus briefs in a lot of these very cases. the arguments, the law, the history, from a legal standpoint, from the standpoint of what we learned to do as lawyers in law school, it's unanswerable. Qualified immunity isn't in the statute. It didn't exist until the late 19th century. It was invented, the late 20th century. It was invented and then imposed, and we're dealing with it now. And I wrote a cert petition which addressed not so much the legal arguments, because apparently they don't seem to work, as some more underlying political theory themes that underline democracy and who has rights and who has power. I won't go into that now unless there are questions about it. One of the dramatically important things about qualified immunity is the negative consequences it has for the status of police in our communities. Imagine if you can violate the law and violate the Constitution and be immune. What does that tell the population? Particularly, what does it tell the victim population, or the population from whose folks are more disproportionate numbers of victims are chosen? It's a terrible situation for the police as much as it is for the intended plaintiffs. Of course, in the short run, qualified immunity basically means the defense wins, except in those few cases where the defense doesn't.